Hey everybody, how are you doing? I hope the mic is on because I don't know whether it is or not. I'm Boozy and we're back again for another Legal Funhouse. Before I get to that, I need to be able to read off the names of the Patreon supporters over at lawyersandliquor.com. So a very special thank you to, oh God, I actually got to bring the list up. Sorry, I was asleep in my recliner like 2 minutes ago. Jeremy the Head Fox and Dragor, Jack of all Korgs, Nikolai Tiger, Tezcat Magic, Jack, Wayland Roche, Beaton, Dozer the Trash Panda, A the Weather Fox, Mark Beckwar, Mama T, Uncle Kage, Lisa Lupe, Mark Phaedrus, Netherlinks, Petrov, Neutrino, Tyranth, Buddy Goodboy Esquire, CC Hodder, David Hunter, Ed B. Cali, Feck, Ghost Goat, Grace Shane Gallinger, Ian Delahorn, Jason Knight, Coma, Maelstrom, Mark Whipple, Matt Allaire, Michael Blocker, Pandemonium Hulk, Sean Rabbit, The Dragon Show, Wheelie, and Zeros Line. Okay, everybody. So, what are we on tonight? We're on bankruptcy. We're going to talk about bankruptcy. I know a bit about bankruptcy law. Before we get to that, it's time for the legal news roundup, where we talk about at least 3 stories that I have discovered over the course of the day. Before I do that, I'm going to tell you how my day went. I got snowed in today. I was snowed in, so I stayed home and I worked in this lovely room all day, getting a brief done for the benefit of my clients. It was a pain in my ass. I sat in this small room for about 7 to 8 hours today, getting that brief ready and getting it filed with none of the normal software I have at the office to do it. Oh, you can tell I'm a little tired tonight, aren't I? So that's my day. I hope you're doing fine. The snow's still coming down here in Pennsylvania, so we're waiting to see exactly how much we're going to get at the end of the day. As somebody in the chat has said, disclaimer. Before we do a disclaimer, I have to do the ways to support us. If you like the stuff you see here and you want to see me do more of it, you can always become one of the Lawyers and Liquor supporters over at lawyersandliquor.com/ or patreon.com/lawyersandliquor. You can subscribe to the Twitch channel. If you do either one of those, that'll put you into the Discord hangout where we will be taking questions for tonight's stream as well. We have a couple good ones in there. I was looking at them before we got started. You can also toss your bits all up in my face, for we are Twitch affiliates. You can go to boozybadger.com or streamlabs.com/boozybadger and slide a tip into the bank account, peruse the merch we have there. If you don't want to do any of that, though, that's cool. I am not here to make money. I'm here to hopefully educate you about the law and give you a little bit of fun on your evening. I hope the sound levels are okay. I haven't actually looked down at them. There we go. Jeremy the Head Foxen starting us off.
My big penis.
I really should disable that effect when I'm doing a legal stream, shouldn't I? It would be nice. So thank you, Jeremy. Yeah. Thank you, Dr. Croxham.
Rub those bits all over my face.
We are going to be talking about bankruptcy tonight. A few words before we begin. First of all, please be aware, I am a lawyer. I am not your lawyer. This is an informational and edutational podcast. Is that a word, edutational? I got to take a moment and wonder, is edutational a real word? Informational and edutational podcast, video, whatever it is. That means that anything I'm telling you tonight is a general principle of law for informational, educational, and entertainment purposes only. It is not intended to be legal advice. I am not your attorney. The only way I become your attorney is if you come to my physical office. You sit down and meet with me. I agree to take your case. You pay me a retainer of my choosing, and you sign an engagement letter hiring me to represent you. Please, anything I talk about tonight, run by a licensed attorney in your jurisdiction before relying on it. Do not say a fat guy who acts like a badger on the internet told me this. And for God's sakes, don't start talking about your legal issues in the chat. It's a horrible fucking idea. Why people do things like that? I mean, like, I've seen it on several legal streams now. People are like, my friend said, okay, look, I'm a lawyer. I smell bullshit like a fat kid smells cake. Don't ask me a question in the hypothetical. I know it's not hypothetical. It's something you really did. Don't say you're asking for a friend. I know it's you. You don't have any friends. All right. That said, let's go into our legal news today. Very first, somebody, some attorney has taken, during the pandemic, shit has happened. Shit has changed. The way we handle things has slowed down. A lot of places are holding electronic hearings, like as we saw a couple weeks ago in the case of the defense attorney who walked out on a call in Kentucky. Some have been holding limited hearings for criminal matters. The question being due process rights and the right to a speedy trial guaranteed to all criminal defendants. So, some people have been gaming the fucking system. And this comes to us from the ABA Journal, where most of the cases that we talk about are going to come to us from. A criminal defense attorney in New Jersey has challenged the jury trial moratorium in the state of New Jersey, arguing that cases cannot be paused indefinitely. That's right. Criminal defense attorney Mark A. Berman has argued in a January 20th motion that the New Jersey federal court pausing jury trials in the face of a pandemic is a deprivation of the right of speedy trial for his clients. He cited concurring opinions by U.S. Supreme Court Justice Neil Gorsuch. If you ever find yourself on the side of Neil Gorsuch, arguing with Neil Gorsuch as your guide, things have gone tits up. Ava, go! Show it to me. Thank you very much for subscribing at Tier 1. By the way, if you have your Discord integrated with your Twitch, you can do that in your sites, or integrate it with your Patreon, and you become one of our Patreon supporters or Twitch subscribers. You'll be automatically added to the Boozy Discord, where we do such fun things as work silently together throughout the day, gather together for movie nights, play multiplayer games that you'll catch generally on Fridays or Saturdays here in the chat. Things like that. It's a fun place, a wonderful time. It also lets you ask the questions today. The idea, I love this quote from Gorsuch, though. Even if the Constitution has taken a holiday during this pandemic, it cannot become a sabbatical. The Constitution does not have tenure. It cannot just disappear for the remainder of the semester. Now, the idea behind this is not, it goes into like the justification, like, well, they have large courtrooms, so it's possible to have socially distanced trials. Everything like that, like we're doing those here, like we're doing socially distanced trials in my jurisdiction, and they are a clusterfuck. They're definitely a clusterfuck. Like we have a real estate auditorium. It's rather large. It's where the sheriff sells off like foreclosures and tax sale things in the real estate auditorium. That's where we're holding our criminal trials right now. It's gigantic and it looks funny. Just to have like 12, 14 people spaced out and then a judge at the front. It looks fucking hilariously lackluster and bad. Well, like that's how we were doing them. But I live in a plague zone, and we're just kind of like, fuck it, we're all gonna get sick. Hold the trial. Now Berman's going through this, and he's writing non-essential. But the key to this, the key is Berman told Law.com that he is encouraged by two recent decisions in which federal judges in California dismissed indictments in similar cases. I think that that's a very important thing to note, is that this is not like, I'm here for the Constitution. Berman is seeing a fucking, and his client, by the way, is a rheumatologist who was indicted in September of 2019 on charges of Medicare fraud. Medicare fraud is where you overcharge Medicare, or you charge Medicare for services that you never actually perform. And I just find it fucking hilarious that the way he's defending his client is, there's a global pandemic. We can get the charges dismissed. Gorsuch, take me away. It is certainly a real concern. It's one that in the legal bar we have been talking about since the beginning of the pandemic. It's why we have things like the Zoom trial that I unfortunately raided their YouTube chat with a bunch of furries on. Sorry about that. In Texas. It's very interesting, but Berman's making a great strategy here, which is, well, if you can't try my guy in a timely manner, you just got to let him get away with it. So That's a fun strategy there. The next bit of news, and this is a bit of Schadenfreude for me. Schadenfreude. How do you pronounce that? Schadenfreude? Schadenfreude? Schadenfreude. I don't know. It's German, so I assume it's screamed angrily at people when it's said. But the next bit of Schadenfreude is regarding one of President Trump's, not lawyers, but frequent legal mouthpieces in the world. If you follow the website, if you follow me on Twitch, if you follow me on here, I've definitely talked about this person before. It's L. Lynn Wood. Now, if you don't know who L. Lynn Wood is, watch that movie Richard Jewell by Clint Eastwood about the Olympic Park security guard who was accused of the Atlanta bombing of the Olympics back in the 90s. And L. Lynn Wood is presented as a legal crusader who pursued justice for him and then pursued defamation charges. He was actually a not well respected, but well regarded defamation attorney. He represented the Ramseys, the JonBenet Ramsey family in matters. He represented Richard Jewell. He represented people in lawsuits for defamation. Recently, he decided that he was going to throw all of his legal power behind Donald J. Trump being the appropriate winner of the election. Now, there's a bit of backstory here, but I don't want to blame it for you. But the key to this is a perfect example of why you should watch what you're doing on social media, especially as an attorney, because L. Lynn Wood has been ordered by the State Bar of Georgia to undergo a mental health evaluation. The State Bar of Georgia has asked lawyer L. Lynn Wood Jr., supporter of former President Donald Trump, God, it is nice to read those words, to take a mental health examination after he got kicked off a defamation case for surprising incompetence in election litigation. I want to surprising incompetence. We are shocked, sir. Shocked that you are so incompetent. We feel there must be something wrong with you. Now, Wood has stated that he will not be undergoing the mental health evaluation. He views it as a witch hunt for his political views, which is very interesting, considering that Wood is currently the defendant in a lawsuit brought by some associates that he was very verbally abusive of, to the point where he was like holding sidebars with God during the phone call. Like he was calling them and yelling at them, and they alleged in the middle of the phone calls he would stop and he would go, "Keep it together, Wood," and he'd go, "Yes, Jesus." Like he was having little sidebar conversations, one side of both of them coming out of his mouth on voicemail messages with attorneys that he worked with or that worked for him during that. By the way, let's all appreciate the joy that is L. Lynn Wood. Doesn't this look like a Southern Baptist preacher who's definitely going to get caught in a hotel room with like 18 underaged male hookers? Doesn't he just appear to be that type of person? Like, look at that fucking grin. He looks like a marionette. He looks like a caricature of a crazy person. All that is opinion, by the way. It's opinion. It's not a statement. I don't know whether L. Lynn Wood is crazy or not. And I have to say that because I may have said this earlier. L. Lynn Wood is a defamation lawyer, and they're alleging he's cuckoo bananas. So I don't want to get sued by L. Lynn Wood. Although, I'll tell you what, if I get sued by L. Lynn Wood, I'm going to court in the Badger head. It's just that simple. Lynn Wood has stated his mind is sound. I have broken no rules. I asked what I had done wrong. I was only told it was about my social media comments. My speech. So he's lining himself up for that free speech suppression argument. This is the part that I love because I talked about this lawsuit at length. Wood's former law partners filed a suit over the breakup of their firm, claiming that Wood began acting erratically in 2019. The suit alleged that Wood has said he might be Christ coming back for a second time. That's right, folks. Jesus is back. He's a crazy lawyer in Georgia, and he's for Trump. My favorite portion of this here is, in the Georgia litigation, Wood's verification paragraph said the suit was filed under plenty of perjury instead of penalty of perjury. And what we're talking about is one of the election lawsuits that was brought, where Wood actually did write in his verification. You have to sign these lawsuits when you file them. It's called the verification. And the verification will say that all statements of fact are true and correct to the best of your knowledge, information, and belief, and that it is filed under penalty of perjury. It's an unsworn statement, but it is one that is considered to be under penalty of perjury. Wood signed one with a unfortunate typo, reading that it was signed under plenty of perjury, which frankly, I just fucking love that. I love the idea of Wood just sitting there like, I didn't lie to the court. I have a duty of candor, so I told them I was signing under plenty of perjury. They should understand. So those are our first two legal stories. We got one more for you. This one comes out of Louisville, Kentucky, in the Jefferson County area. A Kentucky lawyer has been suspended from the practice of law. He has been suspended by agreement. He agreed with the bar that it was very important that he serve a suspension and that he should be disciplined for his actions. What actions, you may ask? Well, that would be beating another lawyer in the courthouse with a can of Lysol. That's right. Kentucky attorney Lindsey Scott will not be suspended as long as he commits no new crimes. What had happened in Scott's case? Well, he and James J.R. Moore at the Jefferson County Justice Center were having a wonderful, normal morning when Lindsey Scott began to fight him. The attack victim, lawyer James J.R. Moore, said on Facebook he was peacefully eating breakfast in a courthouse conference room on July 2019 when Scott attacked him with a Lysol can. Moore told a local publication that he got a dozen staples for his cuts. Now, there's a lot going on here that has to be unpacked before I am comfortable making fun of this. There's a few things that you need to know, and it's all kind of laid out more in the disciplinary opinion, which we'll take a look at in a minute. First, Lindsey Scott is not your typical attorney. Lindsey Scott, when he was in the Marine Corps, was falsely accused of rape and attempted murder. He was imprisoned for that. He served 8 years in jail before his conviction was overturned and he was exonerated. That led Scott to become an attorney. He decided he wanted to become an attorney, and he was admitted to the practice of law in the Commonwealth of Kentucky on October 11th of 2002. Now, Scott has acknowledged in the pleading that he suffers from major depressive disorder and chronic post-traumatic stress disorder as a result of the false accusation and the imprisonment that he suffered. He does undergo and participate in mental health treatment through the VA Medical Center. But he has stated that the incarceration and the trial and the trauma has left him with a profound and lasting impact on his mental health. The weirdest thing, and I'll show you this this complaint here in a minute. Actually, I'll show it to you right now. Well, why am I saying it in a minute? I have it up on the screen. Is that by all other counts, Scott is a good lawyer. It's his first offense. He's never had an ethical offense. Granted, he is already in treatment. He has consensually said, well, I should be suspended. He was suspended from the practice of law for 6 months from the date of the violation. The suspension has been probated for 2 years, meaning that for 2 years he will be monitored by the Bar Association, continue to seek mental health care, and go forward on that, and file proof quarterly with Bar Counsel showing continued participation in counseling or mental health treatment, as well as having everything else. He was also fined $85.01 for this. Now, I don't want to make light of anything with Scott. It sounds like Scott is a very unique individual and a very unique case in this. He is an attorney who became an attorney after undergoing some horrible things and mentally has been affected by those things. And just seeking treatment for them. And in those situations, it can be difficult for people to control their anger. But I do want to highlight the description of this. Just after 8 a.m. Hold on, let me bring us up back here. Just after 8 a.m. on July 17th, 2019, a deputy heard a voice call for help from the second floor of the Jefferson County Hall of Justice. Now, I've been there. I know that. I know that courtroom. The deputy responded and found the victim restraining Scott with both men covered in blood. The victim, also an attorney, said Scott had attacked him with an aerosol can for no reason. The victim suffered multiple head and facial lacerations, for which he was transported to the hospital and received stitches. It really sounds like Scott just fucking snapped a little bit, doesn't it? Like it sounds like Scott just kind of, for a moment there. But kudos to him on at least hygienically beating the shit out of a colleague in the courthouse. Yeah, kudos to him, right? Kudos to him. Oh, so tonight's topic is bankruptcy. Now, I'm going to give you actually a little bit of the spiel that I give when I describe bankruptcy. Bankruptcy is a debt relief program. It's something, but it's not what you think of as debt relief. It's not like debt consolidation. Those things suck, by the way. I'll get into that later. Bankruptcy is a legal mechanism. We find it so important in this country to assure that debtors have access to relief from their debts through the court system, that it was written into the Constitution to give Congress the power to form federal rules of bankruptcy. And shortly after the Constitution was adopted in 1800, the United States of America did indeed pass its first bankruptcy law. It's not what we think of today. The very first bankruptcy law that we ever passed in the United States of America was actually for something called an involuntary bankruptcy, and it only applied to merchant debtors. So it was a bankruptcy just for merchants. Just for merchants. Nobody else could get it. Tommy down the street couldn't go get a bankruptcy. And it was an involuntary procedure. Now, the involuntary procedure I'll get into a little bit more, but essentially it's not you asked for the bankruptcy. It's someone forced you into bankruptcy. Now, that was revised a few times. In 1840, first that was repealed, actually, after a while. And then in 1840, we put in another one. It was, once again, a mainly business-oriented bankruptcy. However, it did have now voluntary provisions. Now, the main feature of that is something called the bankruptcy discharge. That's the biggest benefit you get. Now, those didn't have those. Once again, something I'll explain in a minute, because you gotta start right there. All right, you gotta start with the background. That's how we had it there. In 1938, we had the Nelson Act. The Nelson Act was passing yet another bankruptcy code. That is kind of putting us on track to what we have as bankruptcy law today. It allowed for a broader range of consumers to enter into bankruptcy. It really did set the first standard for real voluntary consumer bankruptcies outside of just putting companies or merchants into bankruptcy. It allowed for voluntary ones and expanded the concept of the bankruptcy discharge. Once again, something I'm going to explain in a minute. Hold your fucking horses. All right. That all changed in 1978 when we replaced the Nelson Code from 1938 with our current bankruptcy code that we have right now, that you will locate in Title 11 of the United States Code, known as, because lawyers are creative, the Bankruptcy Code. The Bankruptcy Code created the traditional form of bankruptcy that we have today, with the different chapters of bankruptcy and consumer bankruptcies and corporate bankruptcies and municipal bankruptcies and farm and commercial fishing operation bankruptcies. By the way, wonderful question to ask during a bankruptcy intake. Do you own a farm or a commercial fishing operation? Anyways, expanded the concept of a bankruptcy discharge. Again, hold your fucking horses. I'm getting to it. And it kept going. That's what we have right now. That's the one we're primarily going to be talking about tonight. Now, understand the Bankruptcy Code is revised several times. We revise it on a pretty regular basis. The last major revision was back in 2005. It was called the Bankruptcy Abuse Prevention and Consumer Protection Act. It went into effect in 2006. Ignore the name. It does none of those things. What it did make it do was harder for consumers to get Chapter 7 bankruptcies where none of their assets are liquidated. Hold your fucking horses. I'm almost there to explain what that means. Now, I've gone through the history. What is bankruptcy? Bankruptcy is a form of debt relief. All right, it is a form of stepping out there and saying, hey, you know what? I cannot handle this. I can't get my debts under control. And the idea on that is, in that situation, there should be a mechanism for the honest but unfortunate debtor to petition the courts for relief from their debts. Okay? And by the way, that honest but unfortunate debtor, that's like not my statement. That's not something that I came up with. That is from a court case regarding bankruptcy and the purpose of bankruptcy. The honest but unfortunate debtor who has been overburdened and finds that they can no longer proceed with their normal life, with their normal way of doing things. They have tried so far to make everything right, they've just been unable to. By the way, little tidbit. Bankruptcy came from like bancus ruptus. They were words that meant table and breaking, and it was for bankers in you gotta love this, bankers in medieval Italy, when they ran out of money and they could not transact business, the table that they dealt at in the public areas would be broken. Bancus ruptus, table broke, bankrupt. It's a fun, just little tidbit, no bearing on it. So how does bankruptcy operate today? Well, we have 5 chapters of bankruptcy in the United States under Title 11 of the United States Code. All right, we have Chapter 7, Chapter 9, Chapter 11, Chapter 12, Chapter 13. Now, very briefly, what do those mean? Well, Chapter 7 is a liquidation bankruptcy. Chapter 9 is a municipal bankruptcy. Chapter 11 is a reorganization, a corporate reorganization bankruptcy. Chapter 12 is a family farm and commercial fishing operation bankruptcy. Chapter 13 is a consumer reorganization bankruptcy. Now, they're not difficult. Like Chapter 9, only for municipal governments. That's what Detroit went through years ago. You don't have to worry about that because, and I'm just going to take a shot in the dark here, you're not a municipality. All right? Chapter 11, while there are individual classes, Chapter 11 bankruptcy, it does not primarily apply to most people. You have to have, I believe, over $375,000 of unsecured debt. Unsecured debt being debt that is not backed by some form of collateral to qualify for a Chapter 11 bankruptcy, as well as income that is likewise. Chapter 12 bankruptcy is a very specific form of bankruptcy because Chapter 11 is meant for corporations. Corporations can only take one of 2 chapters of bankruptcy. They can take a Chapter 7 or they can take a Chapter 11. Well, if you're a family farm or a family-run commercial fishing operation, essentially your business is your home in many times, and a Chapter 11 may not accurately capture the relief you should have, but a Chapter 13 is only open to consumers, so they kind of created a special chapter there for those situations to keep people out of Chapter 7. And then Chapter 13 is the individual consumer reorganization bankruptcy. The main focus of what I'll be talking about tonight is a Chapter 7 and a Chapter 13, because those are the 2 types of bankruptcies that consumer debtors tend to have to deal with the most. What's the difference between the 2? Well, here's the difference. It's easier if I put it in the same terms I use with my clients, okay? A Chapter 7 is a yard sale bankruptcy. A Chapter 13 is a payment plan bankruptcy. All right, what do I mean by that? In a Chapter 7 case, the trustee gathers all non-exempt assets that are of value to the bankruptcy estate and sells them, distributing the assets in a pro rata share to your unsecured creditor, and in return you receive something called a bankruptcy discharge. A bankruptcy discharge is freedom from the vast majority of the debts that existed as of the time of filing of your bankruptcy petition. Now, there are caveats to that. All right, the caveats are as follows. First, the bankruptcy estate. What is the bankruptcy estate? The bankruptcy estate is all property of the debtor that is of value. All right, and when I say of value, the way we determine that, the way we determine whether something is of value, isn't of value in a Chapter 7 bankruptcy is, well, on Schedule A, I'll report like your house. Okay, so like a common misconception. If I file a Chapter 7, they're going to sell my house. Almost never happens. Almost never happens. I say almost never happens because if somebody comes into my house and into my office, and they're in a situation where Chapter 7 bankruptcy would result in the sale of their home, I won't put them in a Chapter 7. I put them in a Chapter 13. A Chapter 13 results in the sale of fucking nothing. But the way that you do this is like, say with your house, all right? I look at your house. I go online, I pull your Zillow value. Say your home is valued at $200,000, all right? So off of that $200,000, I immediately, in my head, for a Chapter 7 in my district, subtract the cost of sale. The cost of sale for real estate applied by the trustee in my district is 10%. So 10% of your home's value from Zillow is assumed to be gone for the cost it would take the trustee to sell the home. So now I'm down to a $180,000 piece of property after that subtraction. Now, say after that subtraction, I have a $180,000 piece of property. I take a look at what is your mortgage. You don't own the house free and clear, do you? No. Okay, so I've reported the value at $200,000. I've taken 10%, and that's all in the bankruptcy estate now. All right, that's all in the pot that the trustee looks to. All right, so that $200,000 sitting there, I take 10% off. Now it's down to $180,000 on that asset, $180,000 in the pot. I look at your mortgage. Say you have a $160,000 mortgage on it. Well, now on Schedule D, I report, yeah, this is a $180,000 or $200,000 piece of property, but after cost of sale, there's only $180,000 left. And then there's a mortgage loan right here for $160,000. So really, there's only $20,000 of equity there, trustee, and that $20,000 is in the bankruptcy estate. Now, if it proceeds at that point, at that very point, to go forward, nothing else is filed, the bankruptcy estate has $20,000 in it. The trustee looks to that $20,000. The trustee organizes a sale of all the assets in the bankruptcy estate and then exposes it. So in that situation, yeah, you'd leave your home, but you're not going to lose your home. You're not going to lose your home 9 times out of 10 because of something called exemptions, all right? And that is Schedule C of the bankruptcy petition. There are certain exemptions I can take, and all an exemption is, and the purposes of bankruptcy petition reporting is, say we have $20,000 in equity, right? Well, I can exempt that $20,000 in equity depending where I am as well, all right? And by exempting, thank you, Hayes.
I'm going to come. My big penis.
By exempting that $20,000, like it's amazing. I'm going to come a big piece. Okay, back to bankruptcy. By exempting that $20,000 out, I'm looking at the applicable law. The applicable law being the law that allows me to claim these exemptions. An exemption is just me reaching my hand back into that pot and taking the money back out of the bankruptcy estate for the benefit of my client, the debtor. So, I live in Pennsylvania. I practice law in Pennsylvania. In Pennsylvania, we have 2 sets of exemptions that a bankrupt debtor can choose from. We have our state law exemptions, which are my state's general exemptions from execution for judgments. Sort of fucking suck, just going to be honest. And then I have the federal exemptions. The federal exemptions being the exemptions that are set out in the bankruptcy code. All right? Now, under the bankruptcy code, for a home, for your primary residence home, I can claim up to $25,150 in exemptions against the value of that home. So, you have a $20,000 piece of property sitting in there after subtracting the mortgage and the cost of sale. There's $20,000 in equity sitting in the bankruptcy estate. I have a $25,150 exemption. I can apply to that under the federal exemptions, which I'm definitely going to suggest you take in that circumstance. I can reach in and tell them on Schedule C, I'm going to apply that $20,000 of that $25,000. I'm going to apply it to that home. That comes out of the bankruptcy estate on the home. Now the home is of $0.00 in value. It has no value to the bankruptcy estate. The trustee will not sell it because there is nothing of value in the estate to sell. And the way exemptions work, especially if you're using the federal exemptions, is you have different classes for different types of property. Like you can claim up to $13,000 of personal property, up to the value of $600 per item, to exempt it out of the bankruptcy estate. It doesn't sound like a lot, but here's the secret. I don't have to report replacement values. All right, this isn't like filing an insurance claim and the insurance company says, well, it's going to cost you $900 to replace that television, so it's a $900 TV. That's not what happens here. That's not what goes on, because it's not the cost that you would have to pay to replace it. It's the cost you would get for it if you were to hold a yard sale. And why is that? Because that's how the trustee sells your shit when you have non-exempt equity. They don't go out there and shop for a buyer. They go out there and hire an auctioneer who puts all of your shit on the front lawn and bids off off lots. So you can use the lowest reasonable value to do that. Vehicles, for instance. Kelley Blue Book is a good guide, only on the trade-in value, though, because that's what a dealer's most likely going to give you if you take the car to them. So you take the low trade-in value, and that's considered reasonable on it. And once again, you can extract out any payments you owe on it, things like that. I joke, I say, if you have a retirement fund, it's an almost unlimited exemption. It's not really an unlimited exemption. The exemption has a limit on it, but the limit's of millions of dollars. And you and me, folks, we don't have millions of dollars sitting in our retirement account, okay? So it's almost an unlimited exemption. So what happens if everything's exempted out in a Chapter 7? What happens if there's nothing to sell after that? They don't sell shit. You go to what's called a 341 meeting. You do this in both the Chapter 7 and, as I'll explain here in a moment, a Chapter 13 bankruptcy. All right. The 341 meeting is a meeting to creditors as prescribed under Section 11 U.S.C. 341 of the United States Bankruptcy Code. It's a meeting with the United States trustee who is managing your case. We will call them alternately trustees meetings, meeting of creditors, the trustees examination. It depends. All right. It's basically a big meeting where the Chapter 7 trustee looks at your petition, looks at your file, goes over everything. They ask you about your petition. They ask you about your assets. All of your creditors are invited to show up and attend. It's like a big you owe me money party, except none of them ever show up. Like in the years of practice, I've had one creditor show up one time for this. And that varies based on jurisdiction. My father practices in Kentucky, and the mortgage companies show up constantly there. All right. At the end of that, if you have no assets and there's no indication of fraud, then the trustee signs what is called a return of no assets. They file that with the court. You take a financial management course. You receive a bankruptcy discharge, which, as we discussed earlier, is a freedom from most, not all, most of the debts that were in existence as of the time of filing of your bankruptcy petition. What debts are not affected by a discharge? Well, any debts you've reaffirmed. Student loans, obviously, except for very limited circumstances, are generally not dischargeable unless you meet what we call the Brunner test. In my jurisdiction, the tests differ based on jurisdiction. Medical debt is dischargeable. Somebody in the chat said, oh, medical's not that. Medical's dischargeable. I discharge medical debt all the fucking time. Restitution to a government body, like court order restitution for a criminal offense. Judgments resulting from drunk driving or drug and alcohol accidents. Those are not. Child support, domestic support obligations are not dischargeable. Income tax that is less than 3 years from the assessment date. If it's more than 3 years from the assessment date, it can be dischargeable. It becomes a general unsecured debt instead of a priority claim that is non-dischargeable many times. So that's the basics of Chapter 7, the real basic drill down on it. Now, why would anybody, when they have a choice between a Chapter 7 and a Chapter 13, want to go into a Chapter 13? Well, a Chapter 13 is what I call a payment plan bankruptcy. The idea of a Chapter 13 is that you, over the course of time, like every step that I just went over, the exemptions, the cost of sale, all that stays the same. None of that's changed, okay? The exception is that if you have things of value to the bankruptcy estate at that point, if you have things of value to the bankruptcy estate at that point, that value is not lost. That value does not disappear. It is not sold by the trustee. What you have to do is kind of buy that out. But there is no trustee sale in Chapter 13. Here's the way your general Chapter 13 will work. All right? We look at it. We look at all this. We determine what your disposable monthly income is, your projected disposable monthly income. You commit for a time period of 36 months or 5 years, 60 months. During that time period, you make a payment of 100% of your projected disposable income to the United States trustee over that time period. The trustee distributes that according to a Chapter 13 plan that is submitted to the trustee by approval. And then at the end of that period, you receive a discharge, again, for all of your pre-petition debts. Now, why would anybody do that? Is it just to avoid sale? I mean, certainly I'll have people who come in and they have equity in their homes, a significant equity in their homes, where their home would be sold under a Chapter 7 plan, and that's a reason to put them into a Chapter 13. In that case, the Chapter 13 plan has to at least provide for the payment of the amount of the equity the unsecured creditors would receive had they gone to a Chapter 7. There'd been a sale. So if you have like $20,000 in your home, your Chapter 13 plan has to provide at least $20,000 in payments to all of your unsecured creditors for pro rata distribution. There is another time, though, that would happen. Now, like the second time, and that is you're behind on your mortgage, okay? A Chapter 7 bankruptcy will not stop a foreclosure. And I just had to be very, it won't stop a foreclosure. If you are behind on your house payments and you file a Chapter 7 bankruptcy, because there's no way to pay those arrears up, what they will do is they will file something called a motion for relief from the automatic stay. The automatic stay being a stay against collection actions that goes into effect at the moment of filing for pre-petition debts. And it will stop the sale. It won't stop the sale for long, though, because they'll file what's called a motion for relief from the automatic stay. They'll say, hey, we deserve relief from the automatic stay to proceed under our state court remedies. And the reason we deserve this is because this motherfucker's $20,000 in arrears on their home, and Chapter 7 doesn't provide for us to be full, and even after the bankruptcy's done, we still can foreclose on it. We can't go after them personally, but we can still foreclose on it. So, under Chapter 13 in that plan, we'd say that it's a catch-up plan. The catch-up plan would have to provide $20,000 in payment in arrears at the very least to the creditor to avoid that. In that situation, you could keep your house through a Chapter 13 by paying it up and then staying current. So you'd be making payments to the trustee and payments on your mortgage each month under the Chapter 13 plan, and that would bring, the trustee would pay off your arrears, you would keep your mortgage current, you don't lose your home. The third situation is, hey, remember when I talked about the Bankruptcy Abuse Prevention and Consumer Protection Act back in 2006? Yeah, the purpose of that was really to make it harder for people to get bankruptcies, especially Chapter 7 bankruptcies. And one of the ways they did that was they put something, I did not realize that my chat was a little off to the side. Did you realize that the chat is off the side of the screen, makes it slightly hard to read if you're watching on a TV? No, it's not off the side of the screen. It's right on the screen for me. I switched it over. I moved it over just a little bit. Where was I? I was on a roll. You interrupted me. I was on a roll and you interrupted me. The Chapter 3, the Bankruptcy Abuse Prevention and Consumer Protection Act. Oh my God, fuck George Bush. Anyways, back in 2005 or so, they basically said, too many people are getting bankruptcies. They're getting the Chapter 7s with no assets and everything exempt. How can we stop this? That's Lindsey Graham, in case you're wondering. How can we stop this? And the way that they stopped it was they passed BAPCA, Bankruptcy Abuse Prevention Consumer Protection Act, BAPCPA. And what it put into effect was means testing for the Chapter 7 bankruptcies. The means testing is they take all your income for the last 6 months ending on the month before the month in which you file. So if you file in January, it's 6 months of income stopping on December 31st, all right? They take all that income, they add it all up. All right, they add every penny that you received in income during that 6 month period, and they divide it by 6. That gives them, this is the average monthly income. They multiply that by 12. That gives them, this should be the average annual income. Then they compare it to the household size calculation of median household income for your state as at the time of filing. They reassess those every 6 months, those median calculations based on the IRS. If you're above the median, you are presumptively barred from filing a Chapter 7 bankruptcy. They say there is a presumption of abuse in the filing that you should be able to fund a Chapter 13 plan. Now, that's just one level of means testing. The next level of means testing is a whole thing we do with IRS standard allotments, and is this secured property or is it not secured property, and is the payment above or below the local IRS standard or the national IRS standard, and when you add all that in, are they above or below a certain amount? Because if you fail that, I can run a full means test. And a full means test is like, okay, if over 60 months they would have contributed less than $7,000, then we're going to say that they can't really fund a meaningful Chapter 13 plan, and we're going to let them get a Chapter 7 anyways. If it's between like 7,000 to a little bit more, like I think 12,000, they say, is that 1/4? What they would be able to fund into a Chapter 13 plan, would that be 1/4 of their unsecured debt total. If not, we're going to say it's not a meaningful Chapter 13 plan. We're going to let them get a Chapter 7. If it's over like $12,000, we say, okay, presumptively, no matter what, this motherfucker can fund a Chapter 13 plan, and we put them in there. And that's a huge point of argument for lawyers and trustees, is whether or not somebody is entitled to a Chapter 7 or has to take a Chapter 13 plan on that. Now, after we run your means testing, though, because we have to run in a Chapter 13 too. Why? It determines your commitment period. Are you in a Chapter 13 giving the trustee your disposable monthly income for 3 years, for 36 months, or for 6 years, or for 5 years, 60 months? If you are above median, then you have to do a 5-year plan. If you are below median, then you are committed to at least a 3-year plan, but can take up to a 5-year plan. Why would you do that? Monthly payments. Say it's not what I call the pure income bankruptcy. Say the thing that's putting you into bankruptcy is you have $20,000 of equity in your house, or you're $20,000 behind on your mortgage, and you need the time to catch it up. Well, I have a baseline right there of what it's going to be, so I know your plan's going to have to provide at least $20,000 plus the projected attorney's fees under no look, plus the trustee's commission, because the trustee gets a commission for managing a Chapter 13 plan, and that gives me your plan amount. And if I divide it by 36, say it's like $200 a month that you're paying. You can't afford $200 a month. Okay. So it's not going to be a 3-year plan, but I can stretch you out to a 5-year plan. Your base amount doesn't change in that situation, because I've been fiddling around with your numbers and I've made it look like you only have that projected disposable income. It's not a lie. I don't lie to the court. I just point out, no, you're spending more on groceries than you're telling them you are, aren't you? Let's go through your bank account statements. See all these fucking Kroger's visits? Yeah, you're spending more on groceries than you told me you did. Things like that. And I can stretch that base amount out over 5 years, lowering your monthly payment. And then after 3 years, say you win the lotto or something, you can pay it off. If you win the lotto during that 3-year period, though, there's been a change in your circumstances, and technically, 100% of that has to be devoted to the Chapter 13 plan to pay off 100% of your unsecured creditors. Oh, that's a lot. But that's the basics. That's the basics of bankruptcy. Generally. Why do you do it? You do it because there's pending legal actions. You do it because you've gotten so far behind. You do it because people are getting ready to sue you right now. You do it because you can't make 100% of the payments. You don't do it, and you don't see people do it when they're committing fraud. And that's one of the things I always hate about this, is when people are like, the bankrupt people are bad with their money. Okay, fuck you. Everybody's a little bad with their money at times. But bankruptcy is a legal mechanism, and it exists for a good purpose, to help the honest but unfortunate person through a bad time in their lives, so that they can get a financial fresh start, stand up on their own 2 feet, and move forward out into the world. There is no reason to be ashamed of using a help mechanism that we have over the course of 200+ years developed in the laws of this country, for you to have a judicially mandated mechanism for which you can get relief. Don't buy into the fucking shame. Okay? Don't buy into these fucking shame merchants. They're like, we can help you settle all your debts. Just send us $800 a month. Fuck them. Like, I never suggest debt consolidation companies. You know why? They charge you an absurd administration fee so that you can pay into an escrow that they're going to manage, tell you to let all of your accounts fall behind so they can negotiate a 30% settlement from the funds. Okay, but a good bankruptcy lawyer, if you're in a situation where you can file a good bankruptcy lawyer can make it so even in a Chapter 13, your unsecured creditors are receiving pennies on the dollar for the debt that they owe, not 30%. And we sure as fuck don't charge you 20% commissions to do it. They're vultures. There's no good purpose for them to exist. Hire a fucking bankruptcy attorney. Now, I've got to go. I've got 13 minutes here. I've got to go and turn to the Discord channel for questions that have been asked on this. This first one comes from Buddy Goodboy Esquire. Boozy, if bankruptcy is guided by federal law, why does each state have different property exemptions? Very good question, Buddy, and I can actually answer that with a very good image. What we're looking at right now is 11 USC 522. It is a list of the exemptions in bankruptcy. All those exemptions I was talking about earlier, real estate and everything like that. This is where those appear. And like I told you earlier, in my jurisdiction, you have 2 sorts of exemptions you can choose from. You can choose from the federal exemptions, which appear in here. 11 U.S.C. Code 522D is the listing of those. Or you can choose from your state law exemptions, which are whatever bankruptcy exemptions or judgment exemptions are promulgated within your state. That is my case in Pennsylvania. However, not every state does that. Some states say you can't use the federal exemptions. You have to use our exemptions. You have to use the exemptions that we have put in our law. And what Buddy's asking is, hey, if bankruptcy is a federal law, then why do the states get to tell you that you can't use the exemptions in the bankruptcy code? And it's actually very, very simple. We'll go down to 11 U.S.C. B2 right here. Property listed in this paragraph is property that is specified under subsection D. We're talking about the federal exemptions, the exemptions you can claim. Unless the state law that is applicable to the debtor under paragraph 3A specifically does not so authorize. What that means is your state has the ability to say under bankruptcy law that you cannot use the federal exemptions. You have to use the state law exemptions. So when Buddy says, if it's a federal law, why can states tell you you can't use federal exemptions? And the answer is because the federal law says the states can tell you you can't use their exemptions. Why do states avoid that? No clue. Uniformity of collection actions between bankrupt debtors and preventing unfair surprise to creditors is one. Making sure that everybody's being heard and their core is being heard pursuant to state law in relation to it, so there's no conflict of laws. Simplifying the process. Making sure creditors in that state are all operating under the same set of collection laws and exemptions, so they're not taking actions that could lead to a violation of the automatic stay and the belief that they are bound by the state law and not the federal law. Lots of things. But the key point to remember on that is if the state law does not specifically state that you are bound only to the state law exemptions, you generally will have your choice between the federal exemptions and the state law exemptions. I talked a little bit about my state, Pennsylvania. I said our exemptions fucking suck, and they do. Hold on. I'll see if I can find them. Pennsylvania exemptions judgment. Like, I know the code. I'm just not going to go through it. There we go. Exemptions from execution. This is come on. Where you at, baby? Where you at? No, go to subchapter B for me. Go to subchapter B for daddy. Go to subchapter B for daddy. Here we go. If we go to the Pennsylvania exemptions from execution, this is 42 PACS 8123 A and B. It is the general exemptions from judgment. You can see here that in Pennsylvania law, what would apply as of our bankruptcy would be like $300 of real or personal property, or $300 of personal property. That would include like cash. That would include bank accounts, things like that. It includes like school books. It includes exempt particular property, wearing apparel, Bibles, school books, sewing machines, uniforms. Generally, retirement fund accounts can be exempt. Some insurance proceeds, but not a lot of shit, right? Like not a lot of shit there, especially compared to the fact that if you look at that, like, you know what's not there? Any exemption for real property. There's no exemption for real property in a Pennsylvania law from execution. You can't exempt it. Now, a situation where I may use the state law exemptions is very specific. It is like, say I have a husband and wife come in, and the wife needs to file a bankruptcy, the husband does not. All right, and they have a home that's worth $150,000, and they own it free and clear. Now, if I was taking the federal exemptions, I would have to report her as the one-half owner of a $150,000 piece of property, which puts $75,000 in equity on the end of the day. Okay, $75,000 in equity, less the 10% cost of sale. So really $70,000 in equity, or somewhere around that. Less the cost of sale at that point. So $70,000 in equity, but I only get $25,150 to exempt out. So like, I'm still looking at $30,000, $40,000. There's no way I can exempt all that out. So how do I do it? Well, the husband's not filing bankruptcy, right? Right? The husband's not filing bankruptcy. So I look at the mortgage. I look at how they own the property. In Pennsylvania, we have a special form of ownership for husbands and wives. It's called tenancy by the entireties. It's a form of ownership of property that is specific to husbands and wives for property that they have obtained together during the course of the marriage. It's a form of joint ownership, and it cannot be attacked by outside parties. It can't be attacked by a creditor like that. And tenancy by the entirety's property is exempt from execution of any creditor who is not a creditor of both husband and wife. So if I look at that situation, they have that there, and they don't really have a lot of joint debts, or they have no joint debts that would be able to come in. I'll say, you all don't have any joint debts outside like the mortgage. And you don't have, credit cards that you both join on. You don't owe money on that. All of your property that you own together as husband and wife that was purchased during the course of the marriage, including your home, is automatically exempt under the state law. So maybe we want to consider the state law exemptions. And I've done that before, and then I've turned around and I've said, okay, now we're going to whipsaw them. I've gotten the wife a discharge, and I said, okay, husband, you're up next. Brought them and put them into Chapter 7, put them under the tenancy by the entirety's exemption under the state law, and whipsaw them. I've got a discharge for the wife, then got back and got a discharge for the husband under the same thing. There's nothing they can fucking do about it. We call it the whipsaw in my office. So it's a lot of fun. But it's state specific on what exemptions you have. And that's why I was saying earlier, this can't be legal advice for you outside of general principles, because you got to talk to somebody who knows the law in your jurisdiction when you do that. Next question. Quaxum. Can you go over the basic differences between a personal bankruptcy versus a corporate bankruptcy? Very basically, yeah. When it comes down to a Chapter 7, there are no differences, except for the fact that corporations are never entitled to a bankruptcy discharge. Corporations never get relief from their pre-petition debts in a bankruptcy procedure. They don't get discharges. And a Chapter 7, at the end of the day, the company's not there anymore. All right? Really, it's more of a winding up thing. It's putting all creditors on notice that the company doesn't exist anymore. I'm taking the company through bankruptcy for judicial determinations that they are now a bankrupt company, that they are insolvent. In a Chapter 11, is essentially a very complicated Chapter 13. It is specific for the corporate form. Like, you can't take an LLC into a Chapter 13. You have to take an LLC into a Chapter 11 because it's a corporate form. It's a business entity. It has to go through a Chapter 11 bankruptcy. In that situation, you're going to have a bankruptcy plan, much like you do in a Chapter 13 for an individual consumer, except the bankruptcy plan is going to be voted on and approved by classes of debtors. It's going to propose reorganization and payment of debts in a certain way, and then the creditors themselves, the different creditors themselves, are going to be involved. Instead of like the trustee pursuing the interests of the creditors, you're going to have a committee of unsecured creditors, generally the 20 largest unsecured creditors, who are going to be protecting those interests. You're going to propose for the sale of assets or the negotiation of debts and things like that to try to bring assets into the estate to pay for the unsecured creditors. Then at the end of it, it's done. It's done. They don't really get a discharge. You've just accepted the plan. So there's no real discharge from debts for corporations. That's the biggest difference right there. Especially in a Chapter 7. The only time that a business can go through a Chapter 13 or a Chapter 7 in the same form that an individual would do is if it is a sole proprietorship. A sole proprietorship is a corporate form that is not a separate business entity. It's really just the person doing business. Kikahoda. What do you think of the current use of judicial estoppel in bankruptcy? This is actually a really good question. The example that they're going to, and I'm going to use their wording because it's a good example. Debtor loses job. Debtor files suit and/or workman's comp claim against company. Debtor declares bankruptcy. Does not include suit or claim on schedules. Debtor receives discharge. Company gets wind of discharge. Asserts judicial estoppel defense in suit or claim. Suit or claim is dismissed. What you just actually described as bankruptcy fraud. I just want to be very clear. All right. The trustee does not only take possession of assets. The trustee takes possession of claims you have that could be of value to the bankruptcy estate. Unless the trustee releases those claims back to the debtor, it is the trustee's realm to pursue those claims, collect upon those claims, and distribute the return of those. So if you knowingly and intentionally fail to disclose a pending claim in a bankruptcy to the trustee, what happens is you've kind of committed fraud. You have failed to report an asset. In this case, the judicial estoppel is probably the least thing that happens. The judicial estoppel is essentially, this happened in that proceeding, so they should be barred from asserting it here. That's judicial estoppel. Um, and honestly, I think that's the least important thing. I understand why it seems unfair. I understand why it can rankle somebody. Somebody saying, well, they didn't mention that claim in bankruptcy, so they can't pursue it against us. But it's really in a sound theory, because if they didn't mention that claim in bankruptcy, then they either A, were committing a fraud and filing a petition and schedules that failed to report what could be a significant asset, or B, they didn't consider it to be a significant asset or a claim that they really had that time, and they should be stopped from bringing it. I know that sounds horrible, but that's the bankruptcy lawyer answer. The appropriate way to do it is to report the claim and either let the trustee pursue it for the benefit of the creditors, or request that the trustee release the claim back to you, or, and this is a good one, report the claim, but exempt out the value of the claim. If it's not a giant claim, exempt the value out, if you can. I have another question here. How many clients' cars have been towed out of your parking lot? None. That's never happened to me. Eddie the Weather Fox. How does one define what type of asset an asset is? I'm curious where model cranes would categorize, and what sort of exemptions can one expect for categories. I can't go through all the exemptions. I really can't. There's just way too many out there. I will say most items that you would think of as a household good are a household good. Your television, although there is a classification for electronics, the exemption category is the general household goods exemption. There is a special exemption category for, say, jewelry, for animals. There's a special exemption category for vehicles, for real property, for financial accounts. And funnily enough, there is no exemption for your bank account. There's none. There's no exemption for it. There's no financial account exemption. There's a retirement account exemption. There's an unmatured life insurance exemption. There is no exemption just for like bank accounts. It doesn't exist. What happens is there's something that we call the wild card exemption that we're allowed to claim under the federal rules that we will apply generally to your bank account. And then any unused portion of your real property exemption up to about $12,000 we can use as a wild card as well. And we'll use that to exempt those out. But it really is, it's very common sense as to what category applies to what type of asset. If it's a household item like a toy, the old model train would be toy or hobbyist equipment or tools. That is generally a household exemption. Now, there are some things like tools of the trade. If you're a carpenter and you need your tools to work, that is a special exemption category. As an individual, what happens after bankruptcy from Head Foxen? As an individual, after bankruptcy, you go forth and you sin no more. When you file bankruptcy, it appears on your credit report. Okay? And I've had to tell people many times now, it will appear on your credit report, and it will stay there for 10 years. It's not 7 years, it's 10 years for bankruptcies. However, I also tend to tell people that it's not 2008 anymore. The financial crash in 2008 and 2009 really kind of redefined the game when it came to how financial institutions look at bankruptcies. It used to be kind of a kiss of death. Now, not so much. A lot of people that you never would have seen filing bankruptcy filed bankruptcy during the Great Recession. And now what they look at is, how have you acted after the bankruptcy? I've had people who are in Chapter 13 bankruptcies buy houses, get approved for mortgage loans because they're 4 years into a 5-year plan. On home financing, most organizations between 2 to 4 years is the danger period where they won't consider you after the filing of a Chapter 7. But after that point, the danger drops down considerably. It has less of an impact as time goes on, especially if after the fact you're able to establish good credit usage patterns and good spending and borrowing patterns. So it's not a financial kiss of death anymore. It hasn't been for about 12 years now. It does get easier as you progress further away from the bankruptcy, even with it still appearing on your report. Now, are you going to get a credit card? No. Not immediately, and if you do, it's going to be with horrible rates. Normally secured balance. You're not going to get good car loans for a while, but that's kind of the price you pay after that fact. As a matter of fact, I have told clients, hey, go get a car loan before you go bankrupt. Why? Because you're going to be reaffirming the car loan in the bankruptcy. It can't be discharged if you get it right now, so there's absolutely no fraud involved, and you'll have a car that'll carry you through the next 3 to 4 years before you'll be approved again at a reasonable rate. Those are things that I've had people do in the past and that I've told people to do in the past. Like, now, I want to be clear. I'm not like, go run up your credit cards. Don't do that. That is... There's actually that's one of the things that makes it clear you're committing bankruptcy fraud. You're abusing bankruptcy if you like take out a bunch of credit with the intention to discharge it in bankruptcy. I am specifically talking about one specific situation where somebody can because they've given cars a certain thing within a certain period of time. After the purchase of a car, the debt is non-dischargeable and cannot be abrogated in bankruptcy, is almost automatically reaffirmed. But right before filing, I'll tell somebody, hey, go get a car. Because your case can't be dismissed, so you're not, that debt won't be dismissed. You'll be well within the time frame where they would preserve the right to have that reaffirmed as a matter of course. It won't be subject to dismissal. Go get a car that's going to carry you through the next 3-4 years and make your fucking payments on it, and you're good. So that will happen. And I have one more question that I do want to go through before we call it a night tonight. This one is once again from Buddy Goodboy Esquire. What's the longest one of your clients has been able to hold on to property without having to pay for it? Okay. This gets into a situation that's got to have to be its own stream at some point, because the difference between a contract under seal and a general contract. All right. First, you have to understand statute of limitations, which is the time frame in which to bring a lawsuit like a mortgage foreclosure action. All right. In Pennsylvania, we have two statutes of limitations that can apply to mortgages. We have the general 4-year statute of limitations, where you either bring the action within 4 years or you're barred from bringing it. We also have the under seal statute of limitations of 20 years. The under seal statute of limitations of 20 years is literally at the bottom of the document. Says this document given under seal gives it a 20-year statute of limitations. I'm going to show you a case called Waniata Valley Bank via Coffee Run Equity Associates. It's a non-presidential case out of the Superior Court of Pennsylvania, which is our intermediate appellate court. If you scroll down far enough, what you'll find out is that while they're saying a mortgage under seal would be 20 years from the date of breach, the date of the first miss of payments, it would be enforceable. A mortgage that is not under seal is only subject to a 4-year statute of limitations to bring a mortgage foreclosure action. If you fail to do it, you lose the right to do it. So I've just got to tell you, don't like look at your mortgages. That's the very first thing that you need to do is go take a look at your mortgage, see whether or not it's under seal, check your state laws, because there are statute of limitations that apply to the ability to bring mortgage foreclosure actions. I will say that lenders are very good about making sure that their mortgages, if they're in an under seal state, are under seal to gain the benefit of the longer period on the statute of limitations. And certain states out there just generally have a 20-year mortgage enforceability thing, specifically for mortgages on real property and especially residential real property. So the question that is being asked by Buddy is, what's the longest one of your clients has held on the property without paying? The answer is 20 fucking years. I've had clients, actually more than one, who have come in and they got a mortgage, and for 19 or 20 years, never made a payment, never made a single payment on their mortgage, and somehow slipped through the cracks. Maybe 3 or 4 successive banks purchased the mortgage, or the bank that held the mortgage, and they just never noticed over 19 or 20 years. And then one day somebody woke up and said, we've never gotten a mortgage payment for this guy. And all of a sudden, my guy's got 20 years in arrears on a 30-year mortgage, and they're accelerating, and they're filing mortgage foreclosure actions, and they're losing their shit, and they give me a call, and we bring them in, and I put them into a Chapter 13, and a lot of times they can't afford the Chapter 13 payments because they're now expected to pay off 20 years of mortgage over 5 years of plan. And they can't manage that, and they keep current payments on the mortgage. Sometimes we'll get them into refinances through the bankruptcy procedure, things like that, because you can occasionally use a bankruptcy to bring a recalcitrant lender to the table on discussing a refinance or something like that. But I've had clients hold on to their homes for almost 2 decades without ever making a mortgage payment, just simply because the bank has lost track of the mortgage. The bank, just for 20 years or 19 years, sat there and were like, we're forgetting something, aren't we? And then one day woke the fuck up and went, oh shit, that guy's never paid us. So that has happened. That has happened. So I will leave it open for about 2 to 3 more minutes here. Looking now at the questions from there done, I'll keep a eye on the chat over there. We'll go to about 8:15. And then we'll call it a night. I do want to remind everybody, if you like these streams, you can always support us, especially for our game streams, by going to patreon.com/lawyersandliquor or becoming one of the Twitch subscribers here. As long as everything's integrated in with your Discord on Twitch and Patreon, you will be able to join the Boozy Badger Discord channel. It should add you automatically. And you'll be a part of all the activities we have, as well as taking precedence in the question asking for this and the front porch streams that I'm going to begin doing monthly again here very soon. You can toss your bits in my face. You can go to streamlabs.com/BoozyBadger or BoozyBadger.com. Take a look at the merch, slide a tip into my bank account, just the tip, though I don't want to get pregnant. Those are always options. I'm taking a look at the chat. I'm seeing if anybody else has any questions before I call it a night. And I turn this off and go upstairs and stare blankly out my window, wondering if I'm going to be working from home again today. The NRA bankruptcy case. I haven't really read up on it. I'll just be honest. I have not really read up on the NRA bankruptcy case. It does not say. Is there a separate category for collectibles, or would they fall under household goods? Good question. Collectibles do fall under household goods in most jurisdictions. Collectibles in and of themselves are not separate things. Now, you have to understand, as I stated, the federal exemption for household goods may be high. It may be like $13,000. But $600 per item is the limit that you can claim on that. So if you come to me like $1,000 collectible, I'm going to say you can only exempt $600 of that. Does a lawyer lie? No. Lawyers lie, yes, but is it like a hallmark of our trade? Absolutely not. As a matter of fact, lawyers owe a duty of candor to court and opposing counsel in many situations. Doesn't mean that we can't massage the facts. It doesn't mean that we can't argue the facts. But we, especially in court and in court filings, we are actually ethically barred from allowing a misrepresentation to go before the court. That is our duty of candor to the tribunal, and we owe general ethical duties to each other to not just flat out lie and misrepresent things in dealings with other attorneys or with unrepresented parties. So I mean, that's it. Are there guys who lie? Yeah, of course. Of course, every profession has those scumbags. But a common misconception is that we lie as a part of our trade, and it's not a part of our trade. If anything, it is very uncommon for an attorney to be openly dishonest with opposing counsel. And if you find out, like between each other, if you base settlement negotiations on like idea A and you find out they lied to you the whole time, okay, you've won one case. Maybe you've gotten one good deal on settlement, but you know what? Absolutely no one in your area is ever going to cut you any slack on a settlement again, because that's all it takes. You burned your credibility many times with the entire bar in the area. So anything else? We're in the last 2-3 minutes, and then I'm out of here. I'm gone. I'll see you all for a game stream maybe tomorrow night and Wednesday night and Thursday night this week. And next week for another Legal Funhouse, hopefully with a guest again. But then I'm out of here. I'm taking the rest of my night. I'm going upstairs and I'm going to eat some cookies. And hope for another snow day tomorrow. Am I excited to go back to FERCON? I miss them. I miss performing. I miss giving lectures. I miss giving talks. I miss seeing people. I miss hugging my friends. I miss spending time with people. I miss talking to people. I miss making people laugh. I do miss them. So yes, I am looking forward to them again. We are talking about chocolate chip, motherfuckers. Somebody asked what type of cookies. Talking about chocolate chip. So yeah, I'm gonna go upstairs. I'm gonna eat myself some cookies. So I am watching the snow. I am going to keep an eye on it throughout the night. Hopefully, it will allow me to work from home again tomorrow. I greatly enjoyed doing it today. But until then, thank you all so much for joining me for another edition of the Legal Funhouse. I hope you learned and were entertained during it, and I hope you'll come back and see me again next Monday at 7 p.m. Eastern Time for another edition of Boozy's Legal Funhouse. Or join me on Tuesday, Wednesday, or Thursday this week for general game streaming here on twitch.tv/Boozy Badger. Until then, I am Boozy. You are not. You have a wonderful evening and good night.